Good afternoon, everyone. Welcome this afternoon to our Aging in Place series on new protections for Colorado renters. And in this session, we will be talking about the protections that the Colorado legislature has enacted for individuals who are renting. So, as you might expect, there's a lot of new regulations, guidelines, and compliance that people have to be aware of. This is true both for the landlord as well as for the tenant. And so we want to take a few minutes this afternoon to look at that. So the first thing that we're going to look at is the landlord's right to collect rent. When you sign a lease, you agree to pay the rent on a certain date. So that rent is due whatever that date that you have agreed upon. Usually it's the first of the month, but it does not have to be. So if the tenant does not pay rent on the first of the month, or oftentimes there is a late date included in the lease as well. So it'll say if you do not pay by day 3, or if you do not pay by day 5, then your rent is considered late. So if the tenant does not pay, this rule was, or this piece of legislation was enacted several years ago, in which we used to have a 3-day pay or vacate. Now, basically, the landlord has to wait 7 days, and then they can begin to charge this late fee and demand their property. Or they can charge the late fee. They have to wait a little bit longer. If the renter pays the rent within the 7 days, then there's no late fee due. And if the renter does not pay the rent, then the landlord can start the eviction process. So just to review, so everybody's kind of on the same page, the eviction process basically, so the tenant is as follows. So the tenant does not pay the rent. The landlord then gives them a 10-day demand for rent or possession. This used to be the 3-day, known as the 3-day pay or vacate. The tenant then has 10 days in which they can pay the rent. And because we can initiate late fees starting on day 7, late fees can be included in this. So the landlord gives a pay or vacate notice on day 11. The tenant then has 10 more days in which they can respond to that. So now we are around the 21st day of the month, assuming that the rent is due on the 1st. If the tenant does not pay, then the landlord can go to court and they can file a summons and complaint. The court then will set a date in which both parties are required or are issued a subpoena to come to court. The court date will be somewhere between 7 and 14 days after the tenant is served. So now we are, if we're really lucky, we're about days 27 or 28 in terms of when the court date is set. If the rent, if that's not, if we're on 14 days, then we're looking a little bit closer to about day 35, since the rent was supposed to be paid. The tenant then has the right to contest the eviction by going to court and paying a filing fee within 7 days. So within that 7 to 14 calendar days in which the amount of rent or the demand to appear in court has been served, if the tenant wants to or is able to, they can pay the fee and they can contest the eviction. If they contest it, then the court will set a trial date. If the tenant appears in court, then the decision is made either in favor of the tenant or in favor of the landlord. If the tenant does not appear, then the tenant loses and the landlord automatically wins. At that point, if the tenant wins, then the tenant is allowed to stay. And if the tenant loses, then we have another process, and that is that the sheriff can or will then supervise the eviction after 10 days. So that then puts us at about day 45, 46, 47. So from day one, when the tenant does not pay, there's an approximately 45-day period of time in which the tenant has the ability to cure the late rent that they have, that they owe. So what's new? So in 2021, the legislature passed House Bill 21-1121, and the Senate passed House Bill 21-173. So the two together are specifically then set up to protect both renters as well as mobile home mobile home owners to avoid eviction and financial burdens, and to basically advance justice for those who are facing evictions. We all know that some landlords can be extremely difficult to work with. So there were 5 basic new protections that were put into place as part of these 2 legislative actions. One is that there are some limits on rent increases. 2 is that there is a warrant of habitability requirement on landlords if repairs are not fixed, and rights that the tenant can exercise. If the landlord does issue an eviction notice, it must include some information and help for renters. Late fees, it puts some parameters around when late fees can be assessed, as well as the amount. And the landlord cannot change locks without a court order. So we're going to look at each one of these new protections individually. So we're going to start with rent increases. So a landlord can only increase a rent once every 12 months. There are no limits on the amount of the rent that the landlord can increase that the landlord can do. So they can do a 20% increase, they could do a 30% increase, they could do a 100% increase. I would expect with the announcement of the Social Security cost of living COLA that we are going to see some pretty significant rent increases over the next few months. In addition to that, landlords must now give a 60-day notice of a rent increase if there is not a written lease agreement. So a written lease agreement will tell you how many days a notice has to be given for a rent increase. If the individual does not have a written lease, then there is a 60-day notice required. So let's take a look now at eviction court. So say that we are on our eviction process where the landlord has waited the 10 days, given notice. The tenant has had their 10 days to respond, and they have not come forward with the rent or has not been able to pay it. So the landlord now decides that they are going to go to court. So once the landlord goes to court and files a summons requiring the tenant to appear in court, or asking the court to require the tenant to appear in court, then the landlord has to include as part of that court summons, when it is served on the individual, information on where the renter can get rental and legal advice. There are a couple of major resources that are available. There is the Colorado Legal Services, which is the resource that probably should be given to everyone Whether they will have the capacity to manage all of these referrals that may be coming their way, I do not know. Whether they have been given some additional resources to manage these referrals or not. There are other agencies around the state that also can help with rental and or legal advice. The renter then has until close of business to go to the court and file the response on the date specified in the eviction notice. So now we are in this 7 to 14 day period, and the renter or the tenant can, in that 7 to 14 day period, if they go to the court and pay basically the fee, then they will not have anything on their record. If they are unable to come up with the money, the renter during that 7 to 14 day period can also go to court, and they can ask for an extension if they need more time to prepare for the trial or the court date. Another protection is that renters who lose in court, we now have 10 days protection. So the last thing in this group, that's another tenant right, is that if the tenant loses, then there are 10 days from which the before the sheriff will come and supervise the removal of the renter's items from the apartment or the house, and the belongings then usually are put out on the city right away for anyone to take or remove. That was a shorter period of time before this legislation passed. The next thing that we have is warrant of habitability. And if we look at warrant of habitability requirements in Colorado statute, we find that there are a lot of things that the landlord is required to do to make the apartment or the house habitable. So they are responsible for making sure that there are no leaks in the roof, in the walls, in the windows, and the doors, that all of that basically works. They're also responsible for making sure that there is working plumbing and gas. So again, the pipes have to be, in the house. The plumbing can't be backed up. I can't have sewer issues, those kinds of things. The landlord is required to provide hot and cold water. So again, the hot water furnace or the hot water heater needs to work. The piping needs to be safe. Colorado does have a lot of lead pipes. Much of that is being replaced at this point in time. But you as a tenant cannot ask the landlord to replace lead pipes. If they are working, then that is outside of the scope of the warrant of habitability. The landlord is also required to make sure that you have a working furnace so that you do not freeze in the winter. Unfortunately, at this point in time, the landlord is not required to provide air conditioning, though many do, I think, at this point in time. The landlord, again, is also required to provide electricity. They do not have to pay for the electricity. They just have to make sure that there is electricity to the unit and that there are no broken fuses or tripped switches. If there are common areas, the landlord is required to make sure that those are clean and sanitary. Another thing that the landlord is required to do is exterminate for rodents. So many of our buildings at this stage of the game suffer from things like bed bugs and other mice and other types of rodents. If you have that situation in your apartment or your home, the landlord is required to contact a pest control company and or work on extermination themselves if they are licensed to do that type of pest control extermination. The floors, the stairways, and the railings on all have to be in good repair, whether that's inside or whether it's outside, on decks or lanais or driveways. Again, all of those things are required to be in good repair. The landlord is required to give you a lock or a security device that works. Again, you can't have locks that either don't have keys that work with them or that are sticky or deny you access to your apartment. The landlord is also required to comply with all of the building, housing, and health codes of the municipality or the county in which they live in. Again, most of those are governed by the local city or county where you live in rather than at the state level. The landlord is required, if they provide you with appliances, they have to work. So if the landlord, when you rent, provides you with a stove and a refrigerator and a garbage disposal, then those 3 items, if they get broken, it is the responsibility of the landlord to fix those. It is not necessarily the responsibility of the landlord to provide you with a dishwasher, with a washing machine, with a dryer. If those things are provided and they are included in your lease and they break or they do no longer work, then again, it is the requirement of the landlord to replace those. The landlord is also required to make sure that the apartment or the house is free of mold. So part of what this legislation did is it created the ability for renters to have what we call an affirmative defense, meaning that if the renter can bring evidence to the court that the landlord is responsible for making their unit safe and habitable and a place healthy to live in, and the renter opts basically to not pay all or some of the rent, even though the landlord has brought the original eviction proceedings. If they're in an eviction situation, the renter has the ability to mount this defense. So the responsibilities of the tenant as part of this warrant of habitability is that you have to send a written notice to the landlord asking them to make repairs. Now, this could be in writing and it could be delivered to the landlord. It could be sent via US mail. It can be done via text message, an online portal, email, however you would normally communicate with your landlord. That written notice, whatever method you normally use to communicate with the landlord, satisfies this requirement. You have to give, as a tenant, the detailed explanation about the repairs that are needed. And again, it's best as a tenant if you explain what those are. So giving a little bit of history about what happened or what you have tried to do. So for example, if the breaker box on the electricity keeps tripping and you haven't added any new appliances, or you're not running something that needs high voltage, but it's just your normal day of things that you do, and the electrical box keeps tripping and you have, not done anything new, then that's a reasonable thing to describe, that all of a sudden now the electrical box keeps tripping when you turn on the light in the bathroom or whatever. You also have to give the landlord permission to enter your home to make repairs. Once you sign a lease, the landlord basically does not have the right to enter your apartment without your permission. The landlord has given that right away. So you have to give that right back to the landlord so that they can come in and make those repairs. You need to also keep copies of any of these notices that you have given. And there's a very specific procedure that needs to be followed. So if you intend to either counsel an older adult or anyone through this warrant of habitability reduction of the rent, make sure that you follow the outline procedure specifically in state law. If and when the landlord then receives this notice, you will want to ask for some type of confirmation that they have received it, whether it's a phone call, whether it's that you set the email so that if they open it, you automatically get noticed. Whatever method it is that you would normally use to make sure that you know that the landlord received this request. The landlord then has 24 hours to start the repairs if there's a danger. If it is a non-urgent matter, then the landlord has 96 hours to start the repairs, which is basically 4 days. If the landlord fails to make these repairs, then your recourse as a tenant is a couple of things. One is you can just simply end the lease and move out if repairs are not made within 5 days, or at least started. You can give a notice with a move out date. Once you take that action, you have to be prepared to actually move. So if you are angry and upset because the landlord is dragging their feet and they're not doing anything, and you say, I'm going to move out in 10 days, then you have to be prepared to do that. If you've given them notice to do that, given the landlord notice. The second option that you have available to you is if it is a situation that is a danger to health or whatever, you can notify the health department or the building department and ask them to come in and enforce those building codes. The landlord then, by order of the city or the county, it will receive a notice from that entity to make the repairs. And if they don't make the repairs, usually there's a fine associated with that. A third option that you have is that you can sue or file a lawsuit in court to force the landlord to make repairs. You can get a court order, and then the court order then requires the landlord to fix whatever is broken. Or the other option you have is that you can sue for damages, and the damage that is caused basically to you by the landlord not fixing the property. Now, the damages could be things like you had to go to the emergency room because you fell on a broken floor, or you fell because the guardrails didn't hold on the lanai or whatever, or you had to go to the hospital because you got mold in your lungs because there was mold present. So if you have those kinds of situations, then you will want to keep all of those receipts and all of those invoices so that those can be presented to the court, and then you can sue for those damages. And then the court will decide what the amount of damages that you are entitled to, and whether you're entitled to any additional fees from the landlord. You can do the fourth option, which is to deduct the repairs from the rent and pay for the repairs using a professional. If you do that, that is basically what if you decide that you're going to fix it and you want the landlord to pay you and you're going to deduct that amount of rent, you must follow a very specific procedure outlined in the state rules. So don't go try to do that without the support, if you will, of an attorney or someone who knows the landlord-tenant rules. You can also go to court and raise the warrant of habitability as an eviction defense, which is what we talked about a couple minutes ago. So moving now to late fees. So when can the landlord charge late fees? So they can charge late fees if it is disclosed in the lease. Okay, so the lease has to say that they will be charging late fees, cannot initiate those until 10 days after the rent is due, or 7 days. So 7 days after the rent is due, then late fees can be assessed. The amount of the late fees cannot be more than $50 or 5% of the monthly rent owed. So if your rent is $800, then 5% of the rent or of the late fee would be $40. So they could charge you $50, but if your rent was $1,500, 5% would be $75, and the landlord could only collect $50. The landlord also cannot charge a late fee more than once a month, and the total amount charged again cannot exceed this $50 or 5%. So they could charge a late fee on day 11 of say $25, and if we get to day 21 and you're paying the rent, they could charge an additional $25 to get to that maximum $50. A landlord cannot charge interest on late fees. So if you are assessed a $50 late fee, the landlord cannot charge you 5% on that, or 10% or whatever. The late fee, the amount of the late fee is what you have to pay. They also cannot charge late fees on subsidized rent. So what this means is that if you have a Section 8 voucher, or you live in a low-income building where you pay, say, $250 rent, and HUD or the Division of Housing pay the other, say, $1,000, the landlord can only charge the late fee on your $250. They cannot charge it on the $1,000 that is paid by HUD or the Division of Housing. If you have paid a certain amount of rent and then you are late, the late fees cannot be subtracted from the rent you have paid. So let's say your rent is $1,000 and you only had $400 to pay on the first. So you give that $400 to the landlord and you agree to owe them $600 more at some date in the future. And you haven't been able to come up with that $600 by day 7, the landlord decides that they are going to assess a late fee. They can only assess the late fee on the $600 that you haven't paid. They also cannot take the $50 late fee out of the $400 that you paid on time. If you are able to pay all of the back rent and the landlord accepts the back rent amount, but you are not able to pay the late fee and the landlord wants you to evict you for the late fee, they cannot do it if the only unpaid amount of money is the late fee. The late fees can accrue from month to month. But again, they cannot charge more than $50 for any month owed. So let's say you got really behind. You got the $50 late fee assessed in October. You were not able to pay it. And now it's February and you're still paying the rent on time, but you haven't been able to pay this $50. the landlord cannot evict you just because of the late fee that you accrued in October. There are some remedies for the tenant, and if the landlord violates these laws, then the tenant can be paid $50 for the first violation, ranging, and then if there are multiple violations, the tenant can be paid anywhere from $150 to $1,000 for additional violations if you give notice, or if they violate the landlord lease requirements that we were just talking about. If those are not remedied within 7 days, then you can go to court. You can bring legal action against the landlord, and then the landlord can, or the court can assess the amount of the fees that that have to be paid to the tenant. You can also always go and sue for financial damages and attorney's costs if you have to go to court. So again, it's trying to hold landlords to a little higher standard, if you will. We are now going to turn our attention to overdue rent. So you have to have time to pay overdue rent. So one of the options for the if you as the renter cannot pay all of the rent, so if you cannot pay it before the court judgment, then the landlord or the court, if you are able to pay it, I'm sorry, and you're facing an eviction, then you can either give the money to the court or you can give it to the landlord, and they have to accept the rent and they have to let you as the tenant stay. If you if the judge confirms that you have paid the outstanding rent, the court then is required to vacate the judgment and dismiss the case, and no eviction filing will then appear on the renter's record. Again, if you are in this situation where the court has ruled that you have a certain number of days to bring the rent current, it is best if, when you are in court, if you arrange for that payment to either be paid to the court or be paid to a third party, so that you avoid any type of disagreement between you as the tenant and the landlord in terms of whether or not it was paid and paid within the timeframes set up by the court. The court may or may not have the monies paid to them directly. They may have another mechanism that they will require that you do. The other thing that this particular piece in the legislation did is it says that in the lease, the landlord or an attorney cannot force you as the tenant to give up this right in any part of the negotiations or the lease. So again, we expect that there will be a lot of new leases drawn up. And one of the things you want to make sure if you're signing a lease is that you do have the right to, if you're late on the rent and it goes all the way to court, that the court or the landlord has to accept it within the time frame set out by the court. The last thing we're going to look at for a moment is changing the locks. And the landlord is not allowed to change the locks without a court order. If the landlord does not have a court order and decides that they are going to change the locks, then you have the right as the tenant to go to court, and the court then can award you the cost of getting the lock replaced back to a workable lock. They can award you all of the attorney's course fees and the court costs, and they can award you 3 times the rent or $5,000, whichever is greater. So if you're paying $1,500 a month rent, and you're late on it and you get locked out, then you can go to court and claim the 3 times the $1,500, which is $4,500. If when you go to court and you are awarded this award, if the house or the apartment has not been re-rented and the judge has heard your case, the judge can also order that you as the renter can be allowed to move back in if you want to continue to look to rent in that building or that apartment. So that concludes our conversation today around tenants' rights and the new changes that were part of the legislation in 2021. Just going to quickly run over a couple of the services provided by the Colorado Gerontological Society. So you can either call our office or visit our website. We do about $1 million worth of vision, hearing, and dental grants every year for low-income older adults. The vision and hearing are available only if you live in Metro Denver. The dental are available if you live in Metro Denver, as well as the Western Slope. Anybody who lives basically west of I-25, except El Paso and Pueblo County. We have the Telephone Buddy program where we can have a volunteer call you once or twice a week to check in on you. We have the Advanced Care Planning where we will provide you with educational information as well as copies of pre-printed forms, as well as we have a pretty significant YouTube video library and some fact sheets on things you need to know on advanced care planning. We do Medicare and Medicaid counseling. We can help with enrollment. We can help with applications. We can help with sort of walking you through the process. We do a holiday basket project for Metro Denver. Baskets are delivered to around 300 to 350 older adults who live on the Saturday before Christmas. We tie this to the Christian holiday of Christmas, but we do not deny anybody if you are of other faiths. You just may get a holiday basket that is not timely for the date you celebrate your holiday. We provide information and counseling on pretty much any topic related to older adults. We recently have signed up for the Denver Basic Income Project. This is available only to residents in the city and county of Denver. And this is a project, a pilot project that they're looking at to try to provide more income to older adults or to anyone 18 and over. We also have an interactive database on our website on the Housing and Home Care Locator. This is designed to help you find resources, if you will, such as home care agencies, adult day programs, hospice programs. If for some reason you are evicted and you need to find other housing, the low-income senior housing units are all listed on this database as well. All of the licensed assisted living and nursing homes are listed, and retirement or independent living units are listed as well. Some of our other programming includes this Aging in Place series, and there is a significant library of topics that we have covered on our YouTube channel. Things like, doing home repairs, bringing services into your home. Again, trying to just give you tools and skills to make you able to continue to live in your own home. We're finding many people who have lived in apartments and homes for many years are anxious to stay there, but need a large number of supports to do that. Our Medicare Monday series runs through open enrollment. So it runs every year from October 15th through December the 7th. And we do some in-person events, some Zoom meetings. We'll do educational programs. We'll help you figure out through individual counseling. If you have questions about moving to a Medicare Advantage plan, a Medicare supplement, prescription drugs, we can help you with those kinds of things. Our Salute to Seniors is an information resource fair. And so we're planning to do that in person in 2023. Our Senior Resource Guidebook lists basically the same information as our Housing and Home Care Locator and is available in libraries throughout the state of Colorado. Our Housing Advocacy Coalition works in two arenas. One is to advocate for housing policies at this level at the state of Colorado, as well as with the city and county of Denver. We are going to be launching after the first of the year a multi-generational family housing support program. We have just finished and are completing a final report on looking at some of the barriers, both systemically as well as emotionally and financially, that have kept families from living together or can cause them undue burdens. And lastly, we have our Latino Services Program, in which we have a Latino Services counselor on our staff who can provide support in any of these areas of services that we offer, as well as she does speak Spanish and is able to provide services in Spanish if needed. And this concludes our formal presentation at this point in time. The slides will be available and will be sent later today to anyone who registered for the class. If you did not register, or you know of people who would like the information, they will also be posted on our YouTube channel, probably either later today or tomorrow.